Let me see. So I'm John Becker. I'm from VCU. Any of my current former students here? Hard to see. See you back there. Only one? Yeah, you know why there's only one? Because I taught the others so well that they don't need to be here. They know everything about the law. But thank you for sticking around. So Brad King talked to you about discrimination on the basis of sex. And I'm going to talk to you a little bit today about discrimination on the basis of race, and very specifically through the lens of affirmative action. So let's see if I can get this to go. All right, so first I have to do my usual disclaimer. All this says is that I went to law school, I graduated, I passed the bar, and then I retired. I retired because they were sending me notices that I had to pay malpractice insurance, and I had to take continuing legal education. And I said, I don't want to do that. And they said, you have to retire. I said, great. So I retired. So I'm officially retired from the practice of law, and all that means is that I can't really give you legal advice. I can only give you sort of my ideas and my opinions about the law, which I will do. So that's my disclaimer. So let's talk about discrimination. So Brad King talked about discrimination on the basis of sex. I'm going to talk about race, but what does discrimination even mean? I'm asking this question because it's actually very relevant to this particular case, because I would argue judges have very different understanding of what even discrimination means. So, you could look up what discrimination means, but just know that that's kind of an important, seems like a simple question, but it's actually a pretty important question for the legal analysis that we're going to do here. And then there's this question about, is it even, legal to discriminate at all? Can we discriminate? And what I like to point out here is that, yes, actually, we can. Your first instinct might be no, discrimination is bad. Well, we discriminate all the time, right? Personally, privately, we discriminate all the time. We say, I like that restaurant better than that restaurant. That's discrimination. I'm choosing that one over that one. That's discrimination. We also discriminate in the law. Public institutions discriminate. One example. You're 7 feet tall, you want to join the Naval Academy. Can't do it. There's height requirements. I think it's 58 to 80 inches. You have to be somewhere in that range in order to enroll in the Naval Academy. Well, that's height discrimination, but they can do that, and we'll talk about why they can do that. So the point is, discrimination can be done, and we're going to talk about when it can be done and when it can't be done. So in the area of race, we have some federal laws that deal with race discrimination. Title VI, Equal Protection Clause, the one we're going to focus on. Title VII is discrimination in the employment context. A bunch of laws that talk about discrimination on the basis of race. We're really going to focus on equal protection, and even more specifically, we're going to focus on this issue of affirmative action. You may have heard over the last fall, 2023, we got a Supreme Court case about affirmative action. I would often say it was a Supreme Court case about race-conscious admissions in college, and that distinction matters to me, and it'll matter as we talk about this a little further, but for most people, this was a case about affirmative action. The case involved Harvard and UNC, one public university, one private university. And in order to understand the issues and how they become relevant to you all, and of course they're relevant, on its face. You have students that want to go to college, they need to understand the admissions process. If the admissions process is going to change, you need to know about that. But there are, I would argue, wider implications of this case than just college admissions. So we have a public university, a private university, and in order to understand the legal issues, we have to understand the facts a little bit. So let's start with Harvard. And here's their application review process, and it's got a lot of steps, basically sort of 4 big steps. The first step in the Harvard admissions process is what they call the first reader. So an individual employee in their admissions office reads the application. This first reader assigns a score in 6 categories: academics, extracurriculars, athletics, school support, personal, and overall. They're scored from 1 to 6. For whatever reason, 1 is best and 6 is worst, but that's just how it is. And so in academics, for example, a 1 is assigned if you have near perfect standardized test scores and grades. So you've aced the SAT, you got 4 point whatever it is these days, you'll get a 1 in the academic category. The overall category, that sixth category, is kind of a composite of the 5 others. So if you get an overall score of 1, the data seem to indicate you have about like a 90% chance of getting into Harvard. Here, what the record indicates in the case, and what Harvard testified to, was that the first reader can and does take an applicant's race into account. How do they take it into account? Not entirely clear. There's certainly no quotas or anything involved, but there is at least admission on the record here that in this first reading, race can be taken into account. We're all humans. People who review the applications are humans. They see the race on the application. It's in their mind, so that's sort of part of the process. Bless you. All right, second part of the process. So after the first reader, it goes to the subcommittee. Subcommittees are organized by geographic region, so there's a subcommittee maybe for the mid-Atlantic area. It's a subcommittee of 5 to 8 people, officers in the admissions office, faculty, and one of them serves as the chair. They're mostly reviewing the 1s and the 2s from the first readers, but sometimes there's a 3 in the bucket as well. It's kind of a long process. Sometimes over months, the subcommittee is reviewing these applications. Here, too, race can be taken into account. Exactly how is not entirely clear, though. From the subcommittee, it then goes on to a full committee. The full committee consists of 40 individuals, and they scrutinize and vote on every application at least once, sometimes more than once. The committee does discuss the relative breakdown of what's been forwarded to them in terms of race. And on the record, what Harvard says is the goal is to make sure that Harvard does not have a dramatic drop-off in minority admissions from the prior class. There's no hard number, there's no quota. They're just kind of looking at things and making sure that things aren't drastically changing. At the end of the full committee meeting, then again, the admissions office will take a look at sort of the composition of the students and demographics of the pool of students who've been admitted. Then there's this last part, which is sort of a weird name, but Harvard calls it the LOP. What is the LOP? Well, that list of all the students that were admitted by the full committee is reviewed, but it's winnowed because often it's too large. So at this point, Harvard considers cutting. Students are placed on the LOP list, but it only contains, when they see this list, it only contains 4 pieces of information: legacy status, recruited athlete status, financial aid eligibility, and race. And then, based just on seeing those 4 factors, the full committee then does this sort of LOP process and decides which students they're going to kind of cut off. So again, they can and do take race into account here, but there's no sort of hard numbers, there's no quota. So that's Harvard's process, 4 big steps in the process. UNC is a little bit different, has some similarities, but it's a much shorter review. In fact, on the record, UNC admitted that they have about 40 reviewers, about individual reviewers. They're expected to read 5 applications per hour, which if you have a child applying to UNC, you should let them know, their application is going to get about 12 minutes of review. All that hard work goes into the application. They get about 12 minutes in the first review. Yeah. So the factors that this individual reviewer is looking at in these roughly 12 minutes include academic performance and rigor, standardized testing, extracurricular involvement, essay quality, personal factors, and student background. But here, too, race is considered as part of these factors. It's part of this sort of overall review that goes on by the individual reviewer. And the reader then formulates an opinion about whether the student should be offered admission, and then writes a comment defending his or her decision. Here, importantly, the reader may offer students a plus, what UNC calls a plus, based on their race, which, according to the record, may be significant in an individual case. All right, so that's the individual review, and then it just goes to a committee review. There's no subcommittee like there is at Harvard. And the decisions made by the first readers are considered provisionally final. That 12-minute review is then considered provisionally final. But then the review committee receives a report, they take a look at it, They see, among other things, their class rank, GPA, test scores, the ratings assigned to them by the initial reader, their status as residents, legacies, special recruit, anything like that. The review committee essentially reviews these provisionally final results and makes it, either approves or rejects what the first reader decided. Here again, they also may consider race, but sort of holistically. There's no quota, no actual number that they're looking for. All right, so that's the process. So having this process in place, there are some students who believe they were denied admission, and they were denied admission because of how race is used in the admission process by Harvard and UNC. Question in the back. There we go. Sorry. Thank you. All right. So some students decided that they believed that they were denied admission, and it was because of the way Harvard and UNC used race in their admissions process, as I just explained. And so they brought the case through the courts, and it reaches the Supreme Court, and the Supreme Court has to decide, may institutions of higher education use race as a factor in admissions? If so, does their race-conscious admission process violate the Equal Protection Clause or Title VI, which I mentioned earlier? And there's really sort of I would say, another way to ask the same question, which is more useful for us, I think, which is, does the use of race as a factor in admissions constitute discrimination in violation of federal law, in this case specifically the Equal Protection Clause? So is the use of race, as Harvard and UNC do it, is that considered discrimination or discriminatory? So what does that mean? Well, the Equal Protection Clause of the 14th Amendment, we heard about the 14th Amendment before in the Due Process Clause. There's also something called the Equal Protection Clause, which is our sort of legal codification of the idea of anti-discrimination. And so the question here is, when is discrimination legal under federal law? So I like to think of legal analysis like physics. Any former physics teachers in the room? Yeah, we got some physics folks here. So I loved physics in high school because I sort of felt like I could easily figure things out. So like, this formula, right? Force equals mass times acceleration. You're presented with sort of a case of like, I'm going to drop this object and I need to figure out if it's going to, break the object that it's falling on. And I can figure out, that's simply a force issue. I need to know if there's going to be too much force to break that thing. And to figure out force, I just need some facts. I need to know the mass of the object that I'm dropping, and I need to know how much it's accelerating. If I can do that, I can figure out the force. Legal analysis is very similar. But in legal analysis, we don't have formulas like this. We have legal standards or tests. And what lawyers do is they apply the facts, they run the facts through the legal standard in the same way that physicists might run facts through their formulas. And so when the Equal Protection Clause is involved, we have a few different formulas that we might use, depending on what kind of discrimination is occurring. If you're discriminating on the basis of race, there's one kind of formula or legal standard. If the discrimination is on sex, there's a different kind of formula or legal standard. If discrimination is on some other kind of classification, there's a third standard. So for example, that other classification, right? I mentioned the Naval Academy, and they essentially height discriminate. They can do that, so long as they pass this test called the rational basis test. And that means that as long as you have a legitimate reason, legitimate governmental interest, and the means that you choose are rationally related to that interest, you're okay. And so the Naval Academy would say, you have to be able to fit in our ships, in our submarines, for example, and so we need you to be a certain height. So we have a legitimate interest there, and these height requirements are rationally related to that. And so they survive this test. They can do that sort of discrimination. If you're discriminating on the basis of sex, there's this sort of intermediate level of scrutiny. Instead of a legitimate government interest, you have to have an important government interest. And your means have to be substantially related to the interest that you're pursuing. The one that we're going to focus on is race, and our legal standard there is called strict scrutiny. Also the name of a very good podcast, by the way, if you like podcasts about the law. But strict scrutiny says that you can discriminate on the basis of race, but you have to have a compelling government interest. So we went from a legitimate government interest to important government interest. Now we're talking about a compelling governmental interest. And the means that you've chosen have to be narrowly tailored towards your goal. So, here's that sort of a little bit more clearly. This is our formula. This is our legal test when there's race involved. So lawful racial discrimination means there's a compelling government interest, and the means that you've chosen are narrowly tailored. Some would say it's like that's the only possible way you can use race to achieve your compelling interest. Now, I'm here to tell you that there are very few interests that are compelling if you're going to discriminate on the basis of race, and the Supreme Court has told us that pretty repeatedly, but we'll see a little bit more about that. So, what might a compelling interest be for Harvard or UNC? Why do they use race in the ways that they do in their application review process? Well, here's what they say. So Harvard says this is what's in the record. Harvard identifies the following educational benefits that it is pursuing. And by pursuing, I mean this is why they use race in their application process, or they consider race. They say they're training future leaders in the public and private sectors. They're preparing graduates to adapt to an increasingly pluralistic society. They're better educating its students through diversity and producing new knowledge stemming from diverse outlooks. All right, so that's their justification. That's their compelling interest. That's why they use race the way they do in admissions. That's their argument. UNC has a very similar argument. They say that they use race the way they do in admissions to promote the robust exchange of ideas, to broaden and refine understanding, fostering innovation and problem solving, preparing engaged and productive citizen leaders, and enhancing appreciation, respect, and empathy, cross-racial understanding, and breaking down stereotypes. That's what they argued before the lower courts and the Supreme Court. So, did the Supreme Court find these compelling? Well, no. Let me tell you why. So, John Roberts, Chief Justice John Roberts, wrote the opinion of the court in this case. It was a 6-3 decision. He wrote for the majority. And he said in the case, outside the circumstances of these cases, our precedents have identified only two compelling interests. Remember I said, very few things rise to the level of compelling governmental interest? Well, John Roberts says there's only two kinds of compelling interest we've ever recognized. One is remediating specific identified instances of past discrimination that violated the Constitution. All right, so remediating past discrimination can be a compelling interest. The second, John Roberts wrote, is avoiding imminent and serious risks to human safety in prisons. That's not at issue here. So John Roberts says there's only two compelling interests that they've ever recognized. Well, and here I'm going to editorialize a little bit. I think that John Roberts kind of waves something away here, which is that he ignores this idea of student body diversity. And why do I mention that? Well, courts' decisions often don't come out of the blue. There have been precedent cases. There have been prior cases about affirmative action in the Supreme Court. The first big case was this case, the Becker case. It was about the medical school, admissions to medical school at the University of California, Berkeley. And in that case, and this is John Roberts' language from this case, he said in the Becker case that Justice Powell, who wrote the decision, turned to the school's interest and he found it to be compelling, which is obtaining the educational benefits that flow from a racially diverse student body. That interest, in his view, was a constitutionally permissible goal for an institution of higher education. So John Roberts himself tells us that in the Becker decision, Justice Powell, who wrote for the majority, told us that obtaining the educational benefits that flow from a racially diverse student body was a compelling interest. Now, John Roberts tells us that was sort of a weird opinion. It's not clear who exactly is in the majority, that it's like a 3-3, 2 decision. It was So there's no real clear majority. But the Supreme Court took this up again at the University of Michigan. Yes. Oh, I'm not advancing my slides, right? All right. So that was the Bakke decision. The Supreme Court brought it up again. University of Michigan Law School, University of Michigan's undergraduate. Two separate cases that were kind of heard around the same time. At the University of Michigan Law School, in that case, there was a clear majority, and the court, Justice Roberts says, for the first time, endorsed Justice Powell's view that student body diversity is a compelling state interest that can justify the use in university admissions. So here, in the University of Michigan, their law school, the Supreme Court said student body diversity is a compelling interest. But for some reason, Justice Roberts sort of waves that away here in this Harvard and UNC case, and comes up with a sort of new way of thinking about this idea of a compelling interest. He brings up this idea of measurable. Because we have required that universities operate their race-based admissions program in a manner that is, quote, sufficiently measurable to permit judicial review. What does he mean by that? Well, if you go back to the statements that UNC and Harvard made, about why they use race the way they do, Justice Roberts says these are commendable goals, but they're not sufficiently coherent for the purposes of strict scrutiny. He says at the outset it's unclear how courts are supposed to measure any of these goals. And if I go back for a second, in citing this idea of measurability, he references the Fisher case. There were a couple of cases about affirmative action in Texas. Abigail Fisher was the plaintiff in those cases. And so he references the Fisher case for this idea of measurability and says in this case, UNC and Harvard aren't producing any interests that are measurable. But how is a court to know whether leaders have been adequately trained, whether the exchange of ideas is robust, or whether new knowledge is being developed? Now, notably, in that Fisher case, which he references, they look at those same kind of goals. And they do say it should be measurable, but then they go on to say that later in the proposal, the university explains that it strives to provide an academic environment that offers a robust exchange of ideas, exposure to different cultures, et cetera, and says all of these objectives, as a general matter, mirror the compelling interest this court has approved in its prior cases. So the things that John Roberts says your interests have to be measurable, cites the Fisher case. The Fisher case says things have to be measurable, and then lists the goals that UNC and Harvard offered and said they're measurable. But now John Roberts is saying they're not measurable. So that's the part of the case that's a little bit kind of confusing to me. All right, so that's the compelling interest case, and John Roberts and the majority says there's no compelling interest here. These are incoherent goals that are not measurable, and so we can't find anything compelling. They could have stopped there, but they go on to the second part of the strict scrutiny analysis, which is about whether their interests were narrowly tailored or not. And I'll just go quickly through that. They basically say their means, the way that the universities use race is not narrowly tailored. And they get at that through this idea that the racial categories that they use are again, kind of incoherent. What is Hispanic? It is clearly complicated. And so, he says it's far from evident how assigning students to these categories and making admissions decisions based on them furthers the educational benefits that they claim to pursue. So he calls these opaque racial categories, and so as a result, we don't have the kind of narrow tailoring that we would kind of need. In fact, he then goes on to use this language, which gives a little more clarity around this idea of narrow tailoring. There has to be the most exact connection between justification and classification. Yes? That what? I couldn't hear you. It's a little bit louder. Not in this case, but stay tuned, because there are already lawsuits claiming that legacy admissions should be gotten rid of too. So whether they'll get to it could take a while if it's going to ever get to the Supreme Court, but it's coming to a courtroom near you. All right, so we don't have compelling interest, we don't have narrow tailoring, therefore it does not survive, the use of race by these institutions does not survive strict scrutiny, and we get, sort of this holding. There's actually, John Roberts adds a couple of pieces to this. He talks about how, in addition to strict scrutiny, the use of race may never serve as a stereotype, and he goes into that. And he also gets into this idea that the use of race must end at some point. He says all race-conscious admissions programs must have a termination point. They must have reasonable durational limits. They must be limited in time. They must have sunset provisions. They must have a logical endpoint. And notably, one of the reasons he says that is from language in the University of Michigan case that I mentioned earlier. Not language from the majority opinion, but language from another opinion. And where Sandra Day O'Connor wrote, "It has been 25 years since Justice Powell first approved the use of race." So 25 years. In the Michigan case, between the Michigan case and the University of California Medical School case, there was 25 years. And Justice O'Connor says it's been 25 years since then, when they said student body diversity is important and compelling. She said, "We expect that 25 years from now, the use of racial preferences will no longer be necessary to further the interest approved today." Well, how long was it between the University of Michigan case and the Harvard and UNC cases? Only 20 years. We hadn't quite gotten to Justice O'Connor's 25 years, but Justice O'Connor says 20 years later, no end is in sight. He's basically saying, yeah, she said 25 years, but we're 20 years here, and there's no end in sight. And so we can't uphold the use of race as done by Harvard and UNC, and so it's unconstitutional, and they struck down their approach. So this thing, John Roberts and the majority sort of strikes us down on lots of different levels. All right, and here's kind of the big holding. He says, we have permitted race-based admissions only within the confines of narrow restrictions. University programs must comply with strict scrutiny. They must never use race as a stereotype or negative, and at some point they must end. Respondents' admission systems, however well-intentioned and implemented in good faith, fail each of these criteria. They must therefore be invalidated under the Equal Protection Clause of the 14th Amendment. So a thorough sort of dismissal of the use of race by Harvard and UNC. Another question? All right, so this is the language from the opinion. He says, the law school was limited in the means it could pursue. These limits, the Michigan case explained, were intended to guard against two dangers that all race-based government action portends. First is the risk that the use of race will devolve into, quote, illegitimate stereotyping. Universities were thus not permitted to operate their admissions programs on the belief that minority students always express some characteristic minority viewpoint on any issue. So the opinion is basically saying these institutions were looking to diversify their student body on the presumption that students of a particular race would bring a particular orientation to the classroom. And for John Roberts, the minority, they're not sold on that idea. They're saying that for the university to say that, let's say, black students bring a particular orientation is stereotyping. Well, yeah, I mean, I listened to the oral arguments in these cases, and this part was a little bit fuzzy, but Harvard and UNC definitely sort of argued that they were not stereotyping, that they didn't assume a particular student of a particular race had a particular orientation. It was all this sort of holistic diversity idea. We just want a diversity of opinions. Not that we think this group is going to bring this opinion, just that we think we want lots of different opinions. That was the argument of Harvard and UNC, but the majority felt like this was basically, putting students into particular buckets and saying they bring this particular orientation, this particular perspective on the world. And so they didn't like that idea. What are the implications for you? Why do you all have to know about this stuff? Well, again, obviously you want to help your students get admitted to college. You need to know about these admission systems and how they're likely to change. And they are changing. It is the case that most universities aren't really dealing with this because they're not as selective as Harvard or UNC. At VCU, I think we admit like 89% of our applicants. And so this is kind of less of an issue for us than some other institutions. So there are clear implications for higher ed, and I see it all the time. But I'm here to suggest that there are a lot of issues that you need to think about as secondary school principals and assistant principals. And it all boils down to like whether or not you think this is a case that's about affirmative action, or you think the Harvard and UNC case was a case about race-conscious college admission. And that's why I said to people, I really think we should be thinking about, when we talk about this case, we should talk about it as a case about race-conscious college admissions, because that's what it was about. And by doing that, we say, well, that's what it was about. It wasn't about affirmative action writ large, because affirmative action is much bigger than admissions. But the more you read about this case, the more commentary you see that says this case is bigger than admissions. What John Roberts and the majority wrote about has implications much wider than college admissions. And so if that is the case, then we have to think about what those might be in the K-12 space. And here are some places where we might see that. We might see it in K-12 admissions, talk a little bit about that, talk about hiring, programming, etc. So, K-12 admissions, I will tell you I'm the proud parent of a rising ninth grader in Chesterfield County. And so we spent the last year going through the specialty center application process, which was interesting, fascinating in fact. And I spent the year teaching this affirmative action stuff and thinking about admissions and going through with my daughter this application process for specialty centers and thinking about, I don't know, could we consider race in the applications to specialty centers? What about schools within a school? All that stuff is possibly implicated here. And I want to point out, go back to an earlier slide where John Roberts was talking about the two times the Supreme Court recognizes race as a compelling interest. He says, one is remediating specific identified instances of past discrimination. His citation there is to a case called Parents Involved in Community Schools v. Seattle, which is our most recent case about student segregation and desegregation. That suggests to me that what John Roberts is saying is that case is still good law. And that we can still, and in that case, the court said, there are very narrow ways that you can use race to sort of integrate your school system. So it is suggestive of the idea that the Supreme Court's not saying that, this gets rid of any use of race in zoning or anything like that. But we have any Northern Virginia folks in the house? TJ High School. So TJ High School is sort of widely recognized, one of, if not the best high school in the country. As in Northern Virginia, it serves 5 different school divisions, if I remember correctly. They had a court case because they changed their admission system. And their case was heard, the Fourth Circuit Court of Appeals made a decision on their case a month before the Supreme Court case on Harvard and UNC, which is certainly interesting timing. And so I want to help you understand the TJ situation a little bit too, because I think it'll help you understand kind of the distinction between higher ed and K-12. So in TJ, they had an old application process where students took 3 standardized tests. Just to get into high school, they had to take 3 standardized tests, and if you scored high enough on those 3 tests, you became a semifinalist, and you would sit for an additional examination comprised of various writing prompts and a problem-solving essay. Semifinalists also had to submit 2 teacher recommendations, and at the end of that process, students were selected from the semifinalist group based on sort of a holistic review of their application materials. Right, so 3 tests, then a 4th test, teacher recommendations, and then the decision is made based on all of those materials. That was the old process. We come along to later years, 2020, all that went on in 2020, the pandemic, George Floyd, all that sort of stuff. People are starting to look at the the composition at TJ High School, the student composition. The board is sort of unhappy with where they are, and at the same time, the Virginia Department of Education, the Secretary of Education, Atif Carney at the time, convened a statewide task force to look at all the governor schools across the state and look at their admissions and their student body composition. So there's a lot going on around 2020, and the school board tasks the superintendent, Dr. Brabant at the time, to sort of come up with some different plans. A lot of plans are sort of bandied about. The board either kind of rejected what he offered or didn't vote on a few of them, but there was just a lot going on, and it took years to come up with a new process. So the new admissions process at TJ, basically each public middle school within TJ's participating school divisions is allocated a number of seats equal to 1.5% of that school's 8th grade student population. So every public middle school, they get the number of seats equal to 1.5% of their 8th grade population. Within each middle school, prospective students are evaluated on the basis of GPA, a portrait sheet, which they create, a problem-solving essay, and experience factors. After each middle school's allocated seats are filled, all remaining applicants, regardless of what school they attend, private school, homeschool even, they compete under the same criteria for the roughly 100 remaining seats. So TJ's incoming class is 100 seats that are kind of general. Everything else is left for each middle school to figure out. And those 100 extra seats are based on sort of a holistic review of their application. So in adopting this new policy, the board had some very specific language. And they said the admissions process must use only race-neutral methods that do not seek to achieve any specific racial or ethnic balance, mixed balance, or targets. So in issuing this new admissions policy, TJ, they were very clear that we're not looking for any specific mix or balance here in terms of race. That race-neutral mandate was codified in the regulations promulgated by the superintendent to implement the policy. So the policy states very explicitly that candidate name, race, ethnicity, or sex collected on the application form will not be provided to admissions evaluators. Each applicant will be identified to the evaluators only by an applicant number. The application reviewers don't even see race when they're reviewing these applications. And so this is the new TJ High School process. What happens is applications increase dramatically, nearly 1,000 extra applications to the school. The mean GPA actually goes up considerably. More low-income students, English language learners and girls, are enrolled in TJ in that first class with the new admissions process. And for the first time in more than a decade, all 28 middle schools in Fairfax County sent students to TJ in 2021, the first year of this. So previously there were 8 schools that sent no students to TJ, 8 middle schools that sent no students to TJ. Now every single middle school is sending some number of students to TJ. So the new admissions process certainly changed some things. Also, pre-revision, the revised policy, 71.5% of TJ High School's student body was comprised of Asian American students. Now that's way different than the population as a whole. But nearly 72% of their whole population was Asian. The rest was basically white students. That was it. 72% Asian, 18% white. After this new admissions policy was in place, their first class of 9th graders, 48% of the applicants were Asian American, 48.6% of the applications were Asian, 54.5% of the offers extended went to Asian students. All right, so 48.6% of all the applicants were Asian, 54.5% of the offers went to Asian students. Now in previous years, anywhere from 65 to 75% of the offers went to Asian students. So there was a drop, but it's still the case that they were offered 54.5% of the seats. Black students received 7.9% of offers and comprised 10% of applicants. Hispanic students were given 11% of the offers and made up 11% of the applicants. So not all that different. In fact, the Asian students were given more offers than the percentage that applied, which is not really true for the other groups. So, but it is the case that the 2021 ninth grade students was, basically 54% of the students were Asian, and in the past they were 71%. So it is a drop. And in fact, a group of students, Asian families, decide to come together and they're going to challenge this new admissions process. And they take it to the courts, goes to the district court. The district court actually rules in favor of the students. And so then it's appealed to the Fourth Circuit Court of Appeals. The Fourth Circuit is where we live. And the question for the court was, is this new application process racially discriminatory in violation of federal law? Or is this even-handed, facially race-neutral application process discriminatory in violation of federal law? And that's important because we have a different kind of review here. So in the Harvard and UNC case, they are using race. And I showed you how they're using race in their admission system. The new application process at TJ is very carefully not considering race. In fact, I showed you how the language that they use in their policy to implement this new process says we don't even have race in the information. And so the Fourth Circuit says this isn't about disparate treatment with respect to race. This is about disparate impact. The Asian students are arguing that the impact of this is disparate. It's worse for them. And when we're talking about disparate impact, we're talking about a different formula, a different physics formula here, right? If there's disparate treatment, like in Harvard and UNC, then we're going to go to strict scrutiny. But if there's a disparate impact, we're only going to use strict scrutiny if there's a disparate impact and that impact, the impact on these Asian students, is traceable to an invidious discriminatory intent. So if these Asian students saw a drop in their admissions to TJ, and that was the result of some, quote, invidious discriminatory intent, then we're going to use strict scrutiny. But in the absence of any kind of invidious intent, we're just going to use that rational basis test. And so the Fourth Circuit says there's no invidious discriminatory intent here. The Asian students argued that the schools very specifically sought to lower the number of Asian students. The court says there's no evidence of that at all. That, maybe the school talked about racial composition, but it wasn't purposefully about lowering the percentage of Asian students. And so there's no invidious discriminatory intent here. So they say, again, no discriminatory intent. And so they just go through this rational basis review. And they basically say expanding the array of student backgrounds in the classroom serves, at minimum, as a legitimate interest in the context of public primary and secondary schools. So here we have the court, they're only doing the rational basis review. There doesn't have to be a compelling interest. There only has to be a legitimate interest. And here we have the court saying, expanding the array of student backgrounds, basically saying student body diversity matters. We think that's a legitimate interest. Now, the Supreme Court may say student body diversity is not a compelling interest, but here we have the Fourth Circuit saying student body diversity is a legitimate interest. And TJ had a legitimate interest in pursuing such diversity. And so the Fourth Circuit upholds the new admissions policy at TJ. That's a pretty big deal because I think it gives us some guidance of how we might think about these things for other admissions areas, for specialty centers. Let's say, for example, hypothetically, you're a regional magnet school and you're focused on computer science or STEM. And you say, we think it's really important to diversify the STEM workforce or diversify the number of the people that go into computer science. And so as part of our application process, we're going to consider race or sex. We want more girls in computer science. So in our admission to our specialty center focused on computer science, we're going to include race in our determination or sex in our determination. Can you do that? Anyone want to guess? Can you do that? If you have starting a specialty center focused on, let's say, computer science, and you want to say, I want to make sure we have 50-50 boys and girls in our specialty center. Well, the question is, what kind of interest what's your interest? You want to make the argument, you'll have to make the argument. If you're talking about race, maybe you have to talk about a compelling interest, but at the very least, you're going to have a legitimate interest in doing so. I would argue, diversifying the computer science workforce, that's a pretty legitimate interest. You could probably, get away with it. But you'll have to be really thoughtful about, why are we doing this? Why are we seeking a diverse student body in this particular specialty center? Same thing with hiring. Can you seek to diversify your faculty and staff? Does the Supreme Court case give us any guidance on this? Maybe. Maybe not. There's a case that I use with my students every semester. It's a case it's sort of a hypothetical case where it's a high school that is predominantly, 90% of the high school student population is black students. 90% of the faculty, staff, administration are white. And they're having all kinds of problems in the school, behavioral problems. And the students are not happy, families are not happy, parents are not happy. And they go to the principal and say, you have an AP opening. We really think you should hire a black AP because that'll help our students. It'll give them a role model, someone they could really relate to, someone they could look up to. What do you do in the hiring process? Can you consider race in the hiring process? Anyone want to guess on that one? Nobody probably wants to touch it, right? It's kind of loaded. Well, again, the question is are we in the land of disparate impact, disparate treatment? In this case, we're probably in the land of disparate treatment. If you want to consider race in your hiring process, that's pretty clearly disparate treatment, and so we're going to have to survive strict scrutiny to do that. Now, how you go about doing it, that's complicated. Are you going to put it in your job description? Probably not. But you could if you believe you have a truly compelling interest. Right? We have to, if we're going to, consider race in diversifying our faculty and staff. If we think it's important that we hire, a black assistant principal because our student body is 90% black, well, is there a compelling interest there? You could argue, pretty convincingly, I would say, that there's a huge body of research. In educational research, we rarely get any agreement on anything. There is an area of research where we have huge levels of agreement, which is around kind of the racial match between the students and the teachers and the administrators. Particularly, black boys do much better in a class with a black male teacher. That shows up consistently across the research. And so this idea of kind of racial matching of the adults and the students in the building is pretty well supported by research. That student outcomes are better. And so you might argue, that's my compelling interest here. I want students to do well. I want them to succeed. State tests, college admissions, whatever. And there's research to back me up that, we have a compelling interest in trying to diversify our administrative staff. So again, the answer is not yes or no. It's whether or not you think your interest in hiring, an AP of a certain race is compelling, and that the way that you've gone about it is, narrow enough that you would survive kind of a legal case. A white applicant coming and suing and saying, I didn't get the job because I was white. Might happen, but if you feel like your interest is truly compelling and you've, kind of really narrowly used race in the most necessary way, you could probably survive a strict scrutiny analysis. Same thing with programming. All the programming that you do in high schools. Here's an example, South Carolina. There was a question about whether the AP African American Studies class would be included on the state list of approved AP courses, and the state said no. They said you can teach that curriculum as part of an honors course, but we're not putting it on our state-approved list of AP courses. And if it's not on the state-approved list, that has all kinds of consequences for the students. Another example, this is a high school in Illinois. They have a black student union, one of their student clubs. What does the black student union do? Well, it's hard for you to read, but it said, it is a student-led organization that focuses on developing young African-American leaders. The Black Student Union seeks to provide a safe and comfortable setting for students to share thoughts, feelings, and views regarding the issues that affect our African-American and black population. Our goal is to celebrate black culture, educate students about black history, promote academic excellence, and model leadership. Then there's some activities that they do. What do we think? In the light of the recent Supreme Court case, can you have a black student union that focuses on developing young African-American leaders? Well, again, we have a test, we have a standard, we have a formula, a legal formula to use to help us make a determination about whether we think we can do this or not, and whether it would survive, a complaint. Do you have a compelling interest in having a black student union that has the goals that I just read there? Maybe. I wouldn't have to make that. Stacy would have to make that argument for you, not me. So it's on her and her colleagues. I don't practice law. I just talk about it. So, I've said, it depends. Do you have a compelling interest? Can you, show that your means are narrowly tailored? That's our formula. That's our legal analysis. For any time you're going to end up in a situation where you're considering race, classifying on the basis of race, like that student union. So, I just sort of want you to consider that, I've said, you can probably get away with it. You can probably survive strict scrutiny. But I also want you to be clear that we live in a time when we have a Supreme Court that it is what it is. We all know the composition. We know 6 justices are appointed by Republican presidents, 3 that were appointed by Democratic presidents. That shouldn't matter, but it does. In fact, we have a Chief Justice who said this in 2007. He said, the way to stop discrimination on the basis of race is to stop discriminating on the basis of race. And I put that up there to say, we live in a time when our judicial system at the very top is really not fond of the idea of any kind of racial discrimination. And I would say further, their interpretation of the Equal Protection Clause kind of gets away from where it was in the past to sort of advance this kind of thought. They're just not fond of any kind of racial discrimination. And that, if that black student union were challenged and brought up to the Supreme Court, who knows? I'm just saying that, John Roberts and the majority, I think, this is kind of their opinion. And they think we're 20 years past the Grutter decision, and we shouldn't have to think about these things anymore. You can agree with that, not agree with that, but that's, the language we're getting from the courts these days. So where are we going next? Well, that's Ed Blum in the picture there. Ed Blum is kind of the guy who is organizing all of these activities. He brought together the Harvard UNC case was brought by a group called Students for Fair Admissions, SFFA. That's Ed Blum's group. Ed Blum is not satisfied. He'd like to go further. He and other advocacy organizations are saying, we won the Supreme Court on affirmative action. It's not just about admissions. They're going after scholarship programs. They're going after workplace diversity initiatives. They just think we shouldn't be thinking about race at all. And so, there's a lot going on. At the same time, you brought up in the back this idea of legacy admissions. There's going to be other consequences too. Legacy admissions, I would argue, I think are going to be struck down. There's no real compelling interest in you don't have to have a compelling interest. There's really no legitimate interest. Universities are going to argue, we have legacy admissions because, they're going to give us a lot of money. Is that a legitimate interest? I don't know. We'll find out. So, I'm going to sort of end there, but I'm going to open up to any questions that you might have. Any questions, comments? Yes. Oh, yeah, yes. So I'll give the organizers there's a link, this is a Google slideshow. I'll give either a link, but also maybe download a PDF if it'll be helpful to you. So, is that it for questions? All right, where are we? I ended right on time, 4:50. So enjoy the rest of your day. Go have dinner on the beach and the rest of your conference, and happy to answer questions.